Hello, good morning and welcome to Newsfile. This is your most authoritative news analysis platform. And here on Newsfile, we put Ghana first. Parliament has had issues with the Attorney General, with the General Legal Council, or those in charge of legal education in Ghana. And they've had issues with the police. This morning, this Newsfile court will resolve the impasse between Parliament, the Attorney General, legal education, and the police. What should be the nature of reforms of legal education? Should it be through a parliamentary resolution actually directing and requiring that the Attorney General will ensure that the General Legal Council will admit some 499 students who say they made the pass mark of 50 but have not been admitted into the law school? Will it be through another law sponsored by private members in Parliament, Roxanne Nelson Eche Dafiamapo and Francis Xavier Sosu, to change how things are done, remove the Supreme Court judges on the General Legal Council, and compel an expansion of education at the professional level? The Attorney General calls the bluff of Parliament, tells them their resolution is misguided. They do not have power to do what they seek to do. The General Legal Council, or the Director of Legal Education, has also been saying a few things, that they are in the process of doing a number of things. Will the Attorney General keep the promise that he says the President has tasked him to ensure that the 499 students are admitted? And the police, do they require prior notice to the Speaker or a warrant of the Speaker to arrest an MP when they commit an offense? We will also be asking the questions about what exactly Bawumia has been talking about: digitalization, ensuring that we have a smart economy. The economy is said to be the fastest growing, but is it digitalized, smart, and yet a broken economy or broke economy? We'll be right back to deal with the vexed matters. I'm Samson Ladi Anyenini. You're welcome back. This is Newsfile. It's your most authoritative news analysis platform. And here on Newsfile, we put Ghana first. My take, I'm beginning a series on road accidents and to see if we can contribute a lot more to help us become aware and to avoid them, because most of them are avoidable. So here's my take: stop the carnage on our roads. Avoid the handset. Avoid the handset. Between January and September this year, we have had 2,126 people killed in road accidents. Just this week, we have had dozens dying in only 2 accidents. It's been confirmed that some of these accidents are the results of people driving and using a handheld device, your mobile phone. Some text and drive, and some have the mobile phone to their ears whilst they are driving. In fact, commercial drivers do that. This morning, I invite you to know that Section 107 of the Road Traffic Regulations 2012 prohibits you from driving a motor vehicle on the road, being in motion, and using a communication device in one or both hands. So it is unlawful to drive while dealing with a handheld mobile telephone device or a handheld device of a kind, any kind. The only people who are exempted from this are the security agencies and those dealing with emergency situations like the fire service. You are allowed only when there's an emergency and you need to make a call to an emergency service, the police or an emergency service, and it is impractical to stop before you make that call. That's the only time when you are permitted to use your handheld device whilst you are in motion in a vehicle. Please take note. When the police arrest you for doing this, don't think they are doing anything wrong. You rather have done something wrong. And if you're arrested, you could be paying up to 600 Ghana cedis or go to jail for up to 3 years. And guess what? On the 27th of October 2020, we made something to our law such that if you decided that you bribe the police officer, you give them some 5 cedis or 10 cedis so that they let you go instead of facing court and paying the fine or getting imprisoned for your misconduct. What you have done is that you put yourself in a situation of potentially going to jail for a minimum of 12 years. A minimum of 12 years. And you could actually go to jail for 25 years for giving a bribe and the officer also accepting the bribe, or you attempting to do so. Let's all do our best to reduce the carnage on our roads. That's my take. And my outfit, as always, is by Habel's Couture. Habel's Couture is at East Legon, at Dringano Gate, East Legon. You can call them on 0200 84 1988. 0200 84 1988. That's Habel's Couture. And you can get the best of some of these, the best of kaftans. Now, let me get ready to introduce my guest to you to discuss the issues that we have tabled this morning. But the show is brought to you by the candid sponsorship of Bank of Africa, as strong as a group and close as a partner, MTN everywhere you go. At Chelsea University, educating ethical and entrepreneurial leaders for Africa. Robert & Sons, seeing is believing. Waylead, home is where one starts. Star Assurance, your solid partner. MG Auto Trading, official distributors of MG vehicles in Ghana. CBG, we stand with you. Fabrimental, your partner in steel. And Rehoboth Properties. We'll be right back. You're welcome back. This is Newsfile. It's your most authoritative news analysis platform. And here on Newsfile, we put Ghana first. My guest, Dr. Dominic Akrotinga Ayine, MP for Bolga East and former Deputy Attorney General and Minister for Justice. I am excited to be his constituent. Professor E. Kofi Abochi, is Dean, UPSA Law School. Martin Pebu, he's a rights activist and a lawyer. SN Dakwa is former clerk of Parliament. He's worked in Parliament from the First to the Fourth Republic. Was a clerk of the Consultative Assembly which drafted the Fourth Republican Constitution. And in the second segment, we shall have Dr. Gideon Boakon, spokesperson and aide to the Vice President, Professor Samuel Chinibua Kodria, senior lecturer, Gimpa School of Technology, popularly known as TK by his students. And Professor Abochi will still be with us, and Godfred Bokwing, Professor of Finance and Economist, University of Ghana. Now, let's welcome my guests who are joining us via Zoom. Martin and Mr. Dakwa, thank you all very much for joining us. All right, I'll begin right here in the studio, and let's start with Professor Abochi on this matter having to do with the MP for Medina, Francis Xavier Sosu. Of course, he has brought it up. His issue has brought the issue up again, but I'm sure that he's not the purpose of the discussion because the matter comes up almost every now and then about the privileges of MPs and the immunities that they enjoy, whether or not they are asserting it rightly or wrongly. So we have had the Speaker, the Parliament issue a statement, on behalf of the Speaker. And the bottom line is that the Speaker is saying to arrest an MP when they have done something wrong, or to serve any processes on them that's coming from court or outside of Parliament, you must follow a procedure. And he says the procedure is that you need the Speaker's permission. That is very categorical. We've had the majority caucus say he's breaching what is the standing procedure. And then we have the minority caucus that is saying that the Speaker is right. What does the law say?
Well, clearly what the law says now is a subject of deep contestation. And so what I say, I'm sure will certainly never get close to resolving the matter. But it's important that at least we have all shifted from the initial, what I would consider to be semi-confusion, i.e. whether there couldn't be an arrest at all. I think when it started, there were confusions as to whether you can arrest a member of Parliament. But it seems that so far the discussion has fundamentally shifted, which is quite helpful. So we are no more contesting whether or not members of Parliament can be arrested. I think what is an issue now is the procedural aspect of the arrest. And the Speaker is saying he performs a gatekeeping role. If you want to arrest any of his members, you need to go through him. That is the part that still remains a bit controversial. My reading of Article 117, which in my opinion is an operative provision, is that a person can be arrested if he's a member of Parliament only and only if you establish that he is not on his way to Parliament, he is not on his way from Parliament, or he is not attending to parliamentary proceedings. He is not on his way to Parliament from Parliament, or attending at, as the Constitution uses the expression, attending at a particular parliamentary proceeding. So a person can be arrested if he's a member of Parliament if he doesn't fall under any of these limited exceptions. Now, Article 117 is a limited exception. The reason it's an exception is because the general rule is that under Article 14, everyone can be arrested except the President of Ghana. In that case, it means for a person to show that he has an immunity of any kind, he must establish it textually. There must be an express provision that basically gives the person or the claimant an immunity under our laws. Article 117 clearly indicates the circumstances under which a person cannot be arrested if he's a member of parliament. The ones arguing against the capacity of the police to arrest a sitting member of parliament read Article 117 in conjunction with 118. Article 118 basically says a person cannot be served with a court summons, etc., to serve as jury, etc., in relation to courts. If the person is a member of parliament and if the person is attending to parliamentary business. And the Constitution goes ahead to say that if there's any doubt as to whether or not a person is attending to parliamentary business, the certificate of the Speaker is sufficient proof. Those who read the two together essentially are saying that 1182 addresses exactly the concerns of 117 in the sense that you cannot arrest a sitting member of parliament unless you have gone through the Speaker. I have indicated that because it is an exception, we have to read it narrowly. You don't read an exception broadly. You read general provisions broadly, and you read exceptions narrowly, because exceptions are narrow. That's what they are. The rule of exceptions is that they carve out a limited provision out of a broader provision. So you don't read exceptions broadly. So because 117 is an exception to the general rule of arrest, you don't read 117 expansively. But those who read 117 and the same way they read 118 indicates that the two appear to play similar roles, i.e. you are coming to interfere with the MP's functional role in Parliament. And because you're interfering with the MP's functional role in Parliament, you have to ensure that the Speaker is brought into the process, i.e. the Speaker being, so to speak, the gatekeeper of Parliament, must at any point in time account for his members. And so because you are about to interfere with the functional role of an MP through the powers of arrest, it is imperative that you go through the Speaker. Indeed, the 1968 Constitution reform, the 1968 Commission that drafted the 1969 Constitution, their recommendations actually pointed out to the capacity of an executive to undermine the functions of Parliament by artificially reducing the numbers of members of Parliament through the power of arrest, especially under critical circumstances. And therefore, they recommended that these powers of the police, in terms of the arresting powers of the police, must be exercised, pursuant to the Speaker, so to speak. Not through the Speaker, sorry. Must be exercised pursuant to a limited exception, i.e. you can't arrest them when they're on the way from performing the functions for which they're elected. The difficulty with that interpretation is if you look at Article 118, even 118, assuming that we decide to accept the combined reading of the two, if you look at Article 118 specifically speaks of the provision in a back-channel format, i.e., if there's a doubt, so it speaks in a doubt format, that is, the certificate to the Speaker is conclusive proof that a person is attending to the business of Parliament, i.e., where there's a doubt. So it doesn't speak of it in a frontal manner. In other words, the police, for example, can go into Parliament and serve summons on someone to perform particular functions. And if the person says, I'm performing parliamentary business, the person is invoking the immunity. If there's a doubt, the Speaker issues a certificate that indicates. Of course, the Speaker can issue it proactively if he wants to avoid the whole confusion. But these things are spoken of in a manner which looks quite reactive, particularly 1182, that the Speaker can react to any doubt by issuing a certificate, and the certificate of the Speaker is conclusive proof. The point I'm just trying to drive at is that the powers of the police to arrest is an expansive power. It ordinarily cannot be constricted, and the circumstances under which it is constricted are clearly itemized. The purpose for the itemization is to ensure that we do not have, if you like, a limitless immunity, so to speak, availing anyone. And whenever anybody claims an immunity, the person must establish it textually in the Constitution. Now, part of the reason why I'm constrained to read 118, and if you ask me, look, my preference conflicts with what I read as a reality. My preference actually is for us to have Article 1182 equally repeated under 117. That's my preference. I.e., the Speaker must at all points in time be involved in the process. I think it helps because it allows for not only institutional autonomy, but it allows for some checks against the executive. Because we should not forget that all these things happening, the police are part of the executive. And for a lot of the difficulties we have now, there's some reality we are not talking about. And that reality is a historical one. The police suffers from a historical deficit of trust. There is a deficit of trust which both parties in government are blamable for. And usually when they're in opposition, they see the problem magnified. When they're in government, they do the same things. And now when parties are in government, they also don't see the problem. When they go into opposition, suddenly they see the problem. So we have a situation in which there's a deficit of trust in terms of institutional manipulation of the police. And because of the institutional manipulation of the police, there's a sense in which any time the police makes a move, particularly against the other organ, there's a perception that somehow the executive is behind this. So that institutional deficit in terms of police manipulation and the deficit of trust is what undermines this. So I would prefer that we have a situation in which 1182 is actually repeated under 117. But if you look at this from a purely constructive, in other words, the construction of statutes and the interpretation of laws, the principle is you do not assume that a lawmaker made a mistake.
Professor Abuchi has been referring to two particular provisions of the Constitution. I just want to read them to you so that we continue. Now, the first provision is Article 117. It says, civil or criminal process coming from any court or place out of Parliament shall not be served on or executed in relation to the Speaker or a member or the clerk to Parliament while he is on his way to attending at or returning from any proceedings of Parliament. We've put that in a slide. We'll put it on the television so that you see it. So that whilst a member is attending to, on his way to, attending at, or returning from any proceedings of Parliament, it says civil or criminal processes coming from outside of Parliament shall not be served on or executed in relation to that member, the Speaker, or the clerk. And the heading of that provision is immunity from service of process and arrest. He also referred to Article 118 and Clause 2 of that. Article 118 is entitled Immunity from Witness Summons. Immunity from Witness Summons. Neither the Speaker nor a member of nor the clerk to Parliament shall be compelled while attending to Parliament to appear as a witness in any court or place out of Parliament. 2. The certificate of the Speaker that a member or the clerk is attending the proceedings of Parliament is conclusive evidence of attendance at Parliament.
Thank you, Samson, for that. So I think the provision speaks for itself. And for me, the problem with interpreting 1182 alongside 117 is to expand the immunity of members of Parliament. And the reason I find that a bit problematic is because the whole point of police powers of arrest is that the police exercises an administrative discretion when they decide on whom to arrest. The power of arrest is a discretionary one, which avails the police once they think that certain elements of an offense are made out and they decide to arrest you and activate the judicial process, so to speak. So once the police decide to do that, the idea that they would have to go through a third person to make a decision in terms of whether or not a person, the arrest process can be completed, in my opinion, it distorts the power of arrest. I think the reason 117 is the way it is, without bringing the Speaker under 117, is to enable that discretionary authority to be exercised. And when it is exercised, and the person has to go to court, and the person is being processed, the additional responsibility of a person who is arrested and who is acting pursuant to the power of arrest, i.e. attending to court, acting as a witness, at that stage, the processes cannot be served on that person unless and until the Speaker is brought into the fray. And the reason that is to ensure that as far as the judicial component is concerned, the Speaker indicates whether or not a person's parliamentary functions will be interfered with and whether or not a person is attending to the functions of his office as a member of Parliament. And as I indicated earlier, we are dealing with a situation of trust. Until we deal with that, this problem will continue. If there's trust in the institutional autonomy of the police, Very often when they exercise these powers, there will be no problem. Indeed, in the UK, where we seem to have copied this, the powers of the police are limited. Oh, sorry. The immunity of the members of parliament is very limited. Limited in the sense of a member of parliament can be arrested at any time for criminal offenses, mainstream criminal offenses, and the immunity is restricted to breaches of State Secrets Act, breaches of slanderous offenses. If the person commits a slanderous offense, for example, there's an immunity. Yes, exactly. So defamation in Parliament or slander, and then contempt of court. Where the person is guilty of contempt of court, slanderous offenses, or breaches of State Secrets Act, those ones, the member of Parliament has immunity. But otherwise, for the commission of regular offenses, there's no immunity. And the reason this is important is because of the rule of law. We must have equality of law, equality of all persons before the law. And it's imperative that as very respectable and as distinguished as members of parliament are in terms of being the cream of our society, it's imperative that there's a sense of equality before the law and accountability when all persons are guilty of anything for which the police decide to proceed against them by way of arrest. I'll leave it here for now.
So when the Constitution says attending to, on its way to, attending at, or returning from proceedings of Parliament, does that include being in your constituency and working as an MP?
That is what I indicated again on Friday. May need some judicial interpretation.
No, I need us to do this.
For us to be clear.
As the law says, does this include being in your constituency and working as an MP in your constituency?
The law doesn't detail out what constitutes proceedings in Parliament. See, that's what I'm just saying. Look, again, because of how vituperative this whole thing has been.
No, but why is it? Why should it be construed as, giving itself to ambiguity? It says proceedings of Parliament is being in your constituency and working there ordinarily, playing your role as an MP in your constituency. Is that attending to the proceedings of Parliament?
Parliament is a corporate body. Members of Parliament are the constitutive entities of Parliament. I have always said this over the years, especially in relation to contempt of Parliament. I have said a lot of the things for which our Parliament has been accusing people of contempt of Parliament. It's actually contempt of parliamentarians. Contempt of Parliament as a body. Parliament is an entity, it's a body, it's a corporate body. Headed by the Speaker in session, you have Parliament in session. I am constrained to say that an MP, Honorable Dominic Ayine, in his beautiful MP, beautiful constituency in the north, Boga East, yes. I'm very constrained to say that when Dr. Ayine is Honorable Ayine,
when he's been invited to attend funerals, attend church services, and all of that, when he's there,
I'm constrained to say that constitutes proceedings in Parliament, because when you speak of proceedings too, you are speaking of structured processes.
You are constrained, or it is not?
You are speaking of structured processes. I'm constrained to say.
I need to move on to others.
Well, I'm just saying I'm constrained because there's no judicial determination yet.
You've spoken for a while, but I'm asking you a few questions so that we are straightforward for our audiences to appreciate what it is. On your way to, attending at, and returning from proceedings of Parliament, does it include being in your constituency and working there as an MP? Proceedings
in Parliament will imply structured processes of Parliament, and I would not think that a member of Parliament, somewhere in Ghana, would be deemed to be attending to proceedings defined the way it is. It looks like a term of
You had made a statement that everyone except the president can be arrested, according to Article 14. That's the police powers that they have. Does that mean that the immunity that the president enjoys, if he committed murder in our face right now, we'll watch him and say because he's president, he has immunity, he cannot be arrested?
The arrest of the president can happen only if you go through prior processes. If the president commits murder, the way he can be arrested is for him to be impeached first. Once he's impeached, the immunity is removed. He can now go through the process. But as he's still president, he's covered.
Or when he ceases to be president,
correct, after
within 3 years
of
ceasing to be president, correct, he can be arrested.
So either he's impeached and then he's taken through the process, or we have to wait till he's out of office within 3 years, which is also another difficulty.
If a president literally can get away with murder, and cannot be arrested until and unless a process, you say prior processes are followed. Why is the MP's immunity not in a similar fashion, that he also cannot be arrested, like the Speaker says, unless he has permitted the arrest?
Well, you're asking someone who doesn't agree with that immunity of the president. I think, and I've said this to my students many times, that we have created a president who, in fact, looks like a chief called the president. And if our people have said this, if you look at the nature of our president, the powers that he has, it appears that there was no model before him. So what they did was basically to look at our chiefs. You don't insult the president, or rather, you don't insult chiefs. The chief is a judge in his own court. So our president is more or less a grandiose chief.
Insulting a chief is a crime in Ghana,
right,
and it's punishable by a fine, and you can go to jail for about 3 to 6 months.
Right. Yeah. So frankly,
if you insult the president, there's no crime.
If the executive is in a coordinate position with Parliament and in coordinate position with the judiciary, I do not see why the president appears to enjoy so much immunity and powers when these two other entities don't. So clearly, in the case of the president, it seems we've just created a big respectable, so to speak, respectable person who enjoys things over and above other people. But I certainly do not agree with the immunity, but that's what it is.
Thank you. The last thing, and some 30 seconds, you were saying that in your opinion, Articles 117 and 118 are independent of each other and separate, and ought not be boxed together.
Absolutely.
Therefore, the Speaker's claim that his warrant to indicate, or his permission for the purposes of effecting arrest under Article 117 is unfounded.
In the circumstances, yes. I think the Speaker doesn't play a role under 117. So my analysis is 118, the Speaker plays a role. The Speaker
so
is the
if Speaker doesn't play a role under 117, it means police do not need the Speaker's permission to arrest an MP when they commit a crime.
Yes, in my opinion.
Okay. But 118 is being brought in, and 118 should relate only to what?
118 relates specifically to what it says. The court summons, court orders.
Witness and
witness. So if you look carefully at it, and thank you, Dominic, if you look carefully at it, you realize that 118 is specifically related to the judiciary, or judiciary orders emanating from the judiciary. And I think the purpose for that, among others, is also for that level of institutional coordination. If you have because court orders are orders. Police arrests are not court orders. And so, for example, if someone evades police arrest, the person hasn't committed any contempt of anyone. Okay. But court orders can create problems in terms of the institutional relationship between the judiciary and the executive. I'm sure we'll get back on this.
So, as Professor Bochi speaks, you find that even though Article 117 is what it is, plain from his point of view, that you don't need the Speaker's prior whatever or permission to arrest an MP when they commit an offense. He's hesitant at allowing that to be what it is because of the potential abuse by the executive. Yeah. Now, I need us, before you come in, I need us to look at what the proposals for the Constitutional Commission for a Constitution of Ghana 1968, what they said, which obviously is what Abochi is talking about. They said at paragraph 429 of their proposals that the history of parliamentary privileges and immunities goes back to the days when the people's representatives were faced with powerful governments which did not spare any effort to intimidate and harass them. These days, when Parliament has no real cause to fear executive interference, these privileges and immunities are less justifiable. Nevertheless, they still retain their essential raison d'etre because they are not considered simply as favors granted to parliamentarians in their personal capacity, but rather as rules designed to secure the complete independence of Parliament. In this light, you say you need the Speaker's permission at all times?
Okay. So, as far as I'm concerned, I think I differ from what the learned professor has, the view that he has articulated. And the reason is very simple. If you look at 117, the marginal note also says service of criminal or civil or criminal processes. Now, civil and criminal processes, all right, emanate from the judiciary. Because, I mean, the police do not themselves, serve civil or criminal processes. They must obtain, let's say, a warrant of arrest from a magistrate or the circuit court or the high court, as the case may be. And then it is that process which is then...
The marginal note is immunity from service of process and arrests.
Right. Service of process. But if you look at the provision itself, it says civil or criminal process coming from any court. All right. So the contemplation here is that these processes will emanate from the judiciary and that they cannot be served on the MP within the circumstances prescribed under 117. That is those that you have spelled out, where the person is attending at, returning from, on his way to, and so on and so forth. All right. Now, I think that there should be a conjoint reading of 117 and 118, because Abochi is right. I mean, Prof. Abochi is right that the gatekeeping role of the Speaker is supposed to ensure that Parliament, as an independent institution or arm of government, all right, is protected from external interference that will, derail its ability to execute its mandate under the Constitution. And so, the person who represents Parliament, right, or the face of Parliament is the Speaker. He is the one invested with powers under the Constitution to lead Parliament in the execution of its lawmaking mandate, and then its oversight mandate under the Constitution. And so, if you have a situation where there is a threat of, external interference or the reality of external interference that could derail the performance of Parliament's mandate, then the Speaker's role as a gatekeeper of Parliament must kick in. Now, Abochi again is right about the fact that in the performance of that gatekeeper role, it is only when there is a doubt as to whether the MP was attending at, returning from, or going on his way to Parliament, that the Speaker's role as a gatekeeper kicks in. So, prima facie, you cannot say that, and I mean, I'm being careful here because the Speaker under the Constitution is the one who can rule on these matters, and he has given a ruling in which he says that you need his permission, all right, in order to be able to arrest, an MP. But I just wonder, as like Prof. Abochi has said, we took these practices and procedures from the Westminster system, okay, and they have had, hundreds of years, of practice with, the issue of parliamentary privileges and immunities. In fact, one of the first cases in which this came about was in relation to defamation, and that is the case of Stockdale and Hansard. So, when we say the parliamentary Hansard, it comes from that name because Hansard was the recorder of the House of Commons. And then in the course of proceedings, he recorded, and published proceedings, and Stockdale took the view that the proceedings were defamatory of him, and then issued a writ against Hansard. It was in the context of that Lord Denman CJ took the view that, look, if you think of the exclusive jurisdiction of Parliament, okay, Parliament is the one that can determine the scope of the parliamentary privilege, all right? And so Lord Denman CJ left it to be determined as to whether or not the published material enjoyed the privilege or immunity from suit, all right, to the House of Commons. Now, let's come forward to 2010, all right? 2010, in the case of R.V. Chater, which was decided by the English House of Lords, okay? In that case, the Speaker, the clerk of parliament then wrote to the House of Lords, wrote to the court and stated quite clearly that what constitutes proceedings of parliament and the scope of the privilege is a matter that must be determined by the court and not parliament. So we can see that from 1840, when Stockdale and Hansard was decided, all the way to 2010, there has been a shift in the position of the English system on whether, who has the power to determine the scope of the privilege. Now, the English position is that it is the court that can determine the scope of the privilege. So it is no longer within the power of Parliament or the Speaker, for that matter, to be able to determine the scope of the privilege that is enjoyed. But you see, Samson, these things, I think the debate has come at a very opportune time in our history as a constitutional democracy. We need to define what we mean by proceedings of Parliament. And I noticed that you are literally cross-examining Abochi on this matter, you know. But I think that it is important that we look at what constitutes proceedings of Parliament. And the example that he gave, if I am in my constituency, attending a funeral in Gambilgo, and let's say that I have committed an offense, and I'm told, the police come with a summons at the funeral to arrest me. The question will be whether or not I am attending proceedings of Parliament, because the key phrase is proceedings, of Parliament. And these must be activities that are intimately connected to the functioning of Parliament as a corporate body. All right. The collective activities of Parliament. And for the sake of, I think we are engaged in some kind of legal education here. So I would beg your permission to cite also the case of R.V. Graham Campbell, ex parte Herbert. All right. That's 1935, 1 KB 594. Now, if you take that case, a very interesting case. So there was a committee of the House of Commons known as the Kitchens Committee. All right. That was, in charge of feeding the MPs and feting them when they are, whilst they are at the House of Commons and so on. Now, 15 of the members decided to sell alcohol, all right, on the precincts of Parliament. Meanwhile, they did not have a liquor license to do so. Okay, so then the police then filed a complaint at the Bow Street Police Station in London against the 15 members, okay, because they sold alcohol without, a license, all right. Of course, when they were taken to court before the magistrate, they claimed parliamentary privilege, okay. The magistrate disagreed with them and said this was not an activity that was intimately connected to proceedings of Parliament, all right, and so they cannot claim the parliamentary privilege, and they were convicted, okay. In the Chater case that...
And this was even in the precincts
of Parliament, yes.
There's a reason I stress that, because in reading the parliamentary history in the Britain, I discover that there is a lot of emphasis in the immunities application to being within the precincts of Parliament.
Right.
Okay.
Yeah. Okay. So, but as I was saying, in the Chater case, which the English Supreme Court decided in 2010. All right. That was also, you remember the expenses scandal. So yes. These 4 MPs, had filed dishonest claims. All right. And their claims, it was discovered through an audit that they had, claimed expenses that were either non-existent or that were not, that ought ordinarily not to have been approved. All right. So they were charged with false accounting. All right. They said, well, these are expenses that were, made or requested pursuant to our functions as members of Parliament. These are allowances that were granted to us under the scheme, approved by the House of Commons. And so we enjoy privilege, we are invoking our parliamentary privilege not to be arrested and prosecuted for the offenses we have committed. All right. So the question before the courts, was whether or not they could claim parliamentary privilege in this circumstance. Interestingly, the Court of First Instance took a view that was very interesting. They said, okay, yes, if these are honest claims, okay, you can claim the privilege. but dishonest claims fall outside the scope of the privilege, and so you can be prosecuted. And that was the issue that went from the High Court to the Court of Appeal, and then subsequently was stated, to the House of Lords for its the Supreme Court for its decision. And the decision of Lord Phillips is very, very interesting. It affirmed the finding by the lower court that these were dishonest claims, and they were not, claims that were covered under the allowance scheme, and so the privilege could not be claimed in those circumstances. I have taken the time to refer to this history because, as we all agree, we took these practice and procedures from the Westminster system, all right? And so the developments in Britain or in the UK for Parliament, for that matter, should guide us in the way we assert either our rights or privileges or powers in the case of Mr. Speaker. I think that Mr. Speaker's assertion of the right to be able to release, what we call an MP, is because he wants to protect the independence of Parliament. But the question is whether that is a right that is cognizable under Article 117 or 118 of the Constitution. And it is very difficult, from the text of the Constitution itself, okay, to say that this is a power that has been granted to Mr. Speaker. So the power granted to Mr. Speaker that is explicit on the face of 1182 is the certification, all right, that a person was, attending at or returning from or on his way to a proceeding of Parliament. Right. And that is conclusive evidence, all right, of the facts stated. Right. So wherever there's a doubt, then his certification, settles that doubt. All right.
When does the doubt come in that I want to arrest an MP who has committed an offense? Of course, if there's no suspicion of a commission of offense, there will not be a question of arrest. Yeah. Or I want to serve a criminal or civil summons or process on an MP. At what time does the question arise if you want us to read 117, 118 conjunctively? Yes. At what time does it arise that we need the certificate
of the Speaker?
And what is the purpose of the certificate? The purpose of the certificate, is it to give permission, or it is simply to indicate that, yes, indeed, if the MP says he's on his way to Parliament, he's attending at Parliament, or he's returning from Parliament, he is speaking the truth. At what time does it arise?
Okay, so we have a live example, and then we don't have to beat about the bush. Right. So on a very fine Sunday, Honorable Francis Xavier Sosu is in church, all right? And then the police are there to arrest him. Okay. Supposing, for the sake of argument, that on that day...
They claim they were not there to arrest him. Well, difficult to believe, but you go on.
Our information, our concrete information, we have concrete information, and we even have the names of the officers who were there. It's not, and the pastor of the church is, a witness. Okay. But let's say for the sake of argument, that they are there to arrest him. And then they serve, an arrest warrant on him. Okay. And then he says, no, I am here in my capacity as an MP to thank the church members for voting for me, or, at the invitation of the church in my capacity as an MP. So
there are two stories I've heard from the church. The pastor has said that Sosu is also a pastor. I suppose you know that.
Yes.
Sosu is also a pastor, and that they have an annual program they do, and they invited him as a preacher. Oh, but I've heard the same pastor say again that he's their MP.
Yes.
And they needed him to come over in the capacity of being the MP.
So let's say that he was in a dual capacity.
Yes, supposing that...
as a pastor and then as an MP.
Right.
All right. And then the arrest warrant is served on me. He says, look, in my capacity as an MP, I am here attending a proceeding of Parliament. Let's say that is what he said.
Okay.
All right. The question then becomes whether it is true that being at church to thank your constituents constitutes proceedings of parliament. And if the police refuse to, to oblige and still went ahead to arrest him, okay, that is when the speaker's certificate kicks in to settle the matter. Okay, if the speaker then issued a certificate saying that being at church in your capacity as an MP constitutes proceedings of parliament, all right, then it will be conclusive, evidence of the fact that these were proceedings of parliament. But even ordinary people will, find such an elastic interpretation of the Constitution a bit absurd, because proceedings, would mean formal, performance of
structured processes.
Of structured processes of deliberation, or voting, and so on and so forth. Okay, so we need to be careful not to overstretch the meaning of proceedings of parliament in order to in seeking to immunize MPs from the criminal justice process, because as the learned professor has said, all right, we are dealing here with the rule of law, and for me, we should not behave as if we are above the law, or we are outside the law. We should not.
Martin, hello. Hello, Martin.
Yeah, Sam.
Okay.
Hi.
So, Martin, you and I have been trying to return to our Eskinme and read it more thoroughly.
Yes.
This is where we borrow everything we know about Parliament.
Yes.
Eskinme says, quote, in all cases in which members of either house are arrested, and I underline arrested, on criminal charges, the House must be informed of the cause for which they are detained. I highlight informed and I highlight detained from their service in Parliament. It has been usual to communicate the cause of committal of a member after his arrest. I highlight after his arrest. Such communications are also made whenever members are in custody. I highlight custody, to be tried or have been committed to prison for any criminal offense by a court or magistrate. Now, and this is from the 23rd edition of Eskinme. From this reading, what's your understanding? The speaker must be informed before or after the arrest, or what? When does it become necessary to require the speaker's certificate? For what purpose?
To reiterate, your question is based on the English practice and law, the English law. With that one, the straight answer is a person that's an MP will be arrested before the speaker is informed. And the point two is that even when he's arrested, I'm reading an older version of Eskinme, but it states that if the detention is brief, the speaker may not inform the House. So the speaker will only inform the House if the detention is for a longer period. Then point number three, Sam, from my reading of Eskinme, is that this privilege never extended to criminal cases. The privilege never extended to criminal cases.
Okay.
The first case where the king released an MP in 1340, it was a civil case. So the MP was in custody for death. Those days, even in Ghana, under our law, a person could be imprisoned for death. It's only in about 2007, 2008, this ex-party Paul Jury case, where our Supreme Court said, no, we should no longer imprison citizens for death. That's a contract.
Yeah.
Previously, there was another Supreme Court case, but let's just say that the 2007 case, the Paul Jury case, sealed it. So the context was that these MPs only enjoyed the immunity if it was for death, trespass to chattel, as we are talking about torts. You say, so it was for only civil imprisonment, not criminal.
You
So when
you just mentioned you just mentioned that you are referencing which edition?
12th edition.
Okay.
And I'm
So
looking
I
at-
just read from you from the 23rd edition,
Yes.
which said they are arrested on criminal charges. It didn't say civil charges.
Yes, so the point I'm making is that I'm tracing the origin.
Okay.
That the history of it. If you look at this one, page 98, maybe I can read portions. It says that the privilege was for civil cases, not criminal ones. So I'm supporting your point that when an MP commits a criminal offense, if we are using the English law, he doesn't claim a privilege from arrest. He cannot, because even from the origins of that privilege, it was not for criminal cases. They said in those days, it didn't extend to felonies and this in breach of surety. Those were criminal cases. In those days, when you are talking about 1340, the criminal offenses were few. So Eskin May says those few ones summed up the criminal law. So the point is that this privilege we are talking about was never meant for criminal cases and was never taken for criminal cases. So if you trace the history, those were civil cases in which MPs owed other persons. So he owed a debt, wasn't paying, then the court, after judgment, will order that he be imprisoned.
So if an MP committed or was suspected of committing a criminal offense, they cannot claim the privilege.
Absolutely.
Okay, so tell us what you think informs the difference in practice as the Speaker seeks to suggest now, and the minority group in Parliament seek to suggest now, that it will appear as if when you need to arrest, you need the permission of the Speaker first.
Yeah, so the difference in the practice is that, Ghana, earlier on you referred to the proposals for the 68 Constitution, 1969
right.
Constitution, where the framers thought that they want to insulate the MPs, right? Yeah, so that is our Ghanaian creation. That's something that was meant for civil cases. We appear to extend it to criminal cases, even though we are not sure. And I joined Professor Bochi in saying that we should leave that to the Supreme Court as to whether we really can claim it in these criminal cases, since the history doesn't support the criminal cases. But the difference going through the Speaker is that so far, I haven't heard my good Professor Dr. Ayini and then Professor Bochi refer to the Parliament Act, Act 300. It's Section 20 of it that says that if you want to execute processes, criminal or otherwise, on a member, then you apply to the Speaker. So may I refer to it briefly? Section 20 of Parliament Act 1965.
Right.
It says immunity from service of process and arrest. 1. Civil or criminal process issuing from a court or place out of Parliament shall not, A, be served on or executed in relation to the Speaker, a member, the Speaker or a member, while the Speaker or Deputy Speaker or member is on the way to, attending at, or returning from a proceeding of Parliament. And then let's go on. So it's like 117, 118. But let's go to the subsection 2, which says the Speaker on an application being made in that behalf may direct that paragraph A of subsection 1, that's the one I read, shall not apply to the service or execution of a criminal process specified in that direction. You see? So this is the basis for the application to Speaker. You write to him, because you see that we don't often see the certificate that much. And this law we've always used from 1965.
Right.
So you see that, and don't forget, even though it appears to be a bit contrary to Article 117, I did a case in the Supreme Court where the Supreme Court said for this green volume, the laws here they are effective because when Justice Crabb did this work, Parliament approved. So until the Supreme Court strikes down this, it is good law. So you apply to the Speaker. So if the Speaker says he's not releasing the honorable member, it appears it's based on the Section 20 because it says apply.
Section 20 says his permission is required.
Yes, it says. Let me read for emphasis.
Yes, go again.
The Speaker, on an application being made in that behalf, may direct that paragraph A, that's the one I read, service, execution, blah, blah, shall not apply to the service or execution of a criminal process specified in the direction. You see, so Speaker may direct. So he writes that, though, I won't release, or I'm directing that he will not be. And as I said, so until this provision is struck down, it means that apart from the Article 118 saying that the certificate, this one says he may direct. And some, the good difference between Section 20 and Article 117 and 118 is that in Section 20, the two, the execution. So you see that in Article 117, there's no provision about the Speaker directing or issuing a certificate. You remember right. Professor Abuchi referred to that.
That's right.
But in Section 20, the Speaker may direct. So it looks like what is lacking in Article 117 is, for lack of a better word, cured in Section 20 of Act 300.
Right. And your reading again is that this is an essential point. Your reading again is that there ought at all times, as the Speaker seems to suggest in this release, be a permission from the Speaker obtained by the police or process service before arrest can take place or a service can be effected. Is that your reading?
No. The Speaker cannot be held to say that at all. If that's the impression, I don't believe that's what he's saying. But if that is the impression, at that point, I depart with the Speaker.
The Speaker said, let me read. The Speaker said, Mr. Speaker reiterates that the immunities and privileges of members of Parliament are not absolute. The procedure for causing the arrest of a sitting member of Parliament or serving a court process must be in accordance with the Constitution. The procedure for causing the arrest of a sitting member of Parliament, or serving a court process must be in accordance with the Constitution. The appropriate procedure is to secure from the Speaker a certificate that the member in question is not attending to parliamentary business. Anything short of this should not be entertained by the House.
No, that's not correct. When you read down, the Speaker reiterates also that, the letter, which seems to have been done on his behalf.
The last paragraph of that letter is 18. It says, the Speaker would want to reassure the people of Ghana that he takes seriously the oath he swore on the 7th of January 2021 by his solemn pledge to, quote, faithfully and conscientiously discharge his duties as the elected Speaker for all, as well as to uphold, preserve, protect, and defend the Constitution of the Republic of Ghana. So if you read down, this is the only thing there.
Sam, let me see if I find another paragraph. I'll make the point whilst I continue. It is that the same letter recognizes that currently some members of Parliament are being investigated and are standing trial.
That's right.
And the number is even as high as about 13. And this Speaker, Sam, he's a lawyer like you and I, older even at the bar. The Speaker cannot be, as I said, for me, I take the position that he's not saying that a member cannot be arrested at all. No. So, the example we've given.
Please, Martin, let's stick to paragraph 17. The appropriate procedure is to secure from the Speaker.
Yes.
What does that mean? It says that's the appropriate procedure, and anything short of this should not be entertained.
No, so okay, for now, let's say That is it. That would be wrong. I was trying to get the paragraph where, in the same letter, the speaker admits that there are other members of parliament who are standing trial.
That's all right. That's all right. But this is an emphatic pronouncement. That for him is the position of the law. That if there is no prior, it says the appropriate procedure is to secure from the speaker a certificate, blah, 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 and that anything short should not be entertained.
No, that's not correct. So as I said, I'm reading the letter as a whole. So for me, because other parts of the same letter has referred to members of parliament who are currently standing trial, my understanding is that the speaker is not saying it's absolute, meaning that if, let's say, as I said, if the person is caught in the very act, in law we like to say in flagrante delicto, right? Mm-hmm. In the very act of committing an offense, let's say an MP pulls out a gun and shoots somebody to death. What? How can we say we would let him go home and then we go chase the speaker for a certificate? No. Citizens arrest under Article 14, and then you look at sections 10, 12 of Act 30. Citizens and the police have powers of arrest. So we will not allow such an MP to escape home. No, we will arrest him. So the speaker's statement here cannot be a total statement of the law. I presume he's referring to cases where the MP has not been caught in the very act of committing the offense.
Should we be presuming for him? Because he's emphatic here. Why are we helping him? He's emphatic. Yes, this is the conclusion of his statement. So this conclusion is very important. He says, 16, that the appropriate, he says that he is reiterating that the immunities and privileges of members of parliament are not absolute. Then in the next breath, he says the procedure for causing the arrest of a sitting member of parliament or serving a court process must be in accordance with the Constitution. So the next step is he's telling us what you have to do. And he says, if you don't prior secure his permission, you are wrong. Anything short of that should not be entertained.
Yes, Sam, we are not helping him. We are just being fair to him. Remember that the letter is written in a context, and you and I know that we interpret based on certain rules. We read the document as a whole, and we look at the context. So the speaker, Honorable Sosu's case, is not about a case where he pulled a gun and shot somebody or slapped somebody. No. So you see that the speaker's mind is not on cases where an MP is caught in the very act. Because I've already referred to the Constitution and Act 30, where ordinary citizens have the powers of arrest, in addition to the police powers. Okay. Sam, kindly, just one last point. Let's refer to paragraph 5 of the letter. This is why he says, indeed, the police service and other security agencies have investigated and continue to investigate members of parliament from both sides. And in all instances, the office of the speaker has engaged and facilitated the work of the police service. Let it not be suggested per these happenings that members of parliament and parliament are not subject to the law. Voila, you see it? Voila. And I heard that there are about 13 or so MPs who are currently being investigated or standing trial, and he's been facilitating. Yeah,
so in that part, he's simply supplying us information. He's not making any emphatic, as it were, pronouncement. He's simply supplying information. So if you ask
for me, that is very key. Sam, it's very key. As I said, I'm using the tools of interpretation.
No, tools of interpretation must not include someone supplying information. If he's supplying us information if he's supplying us information that some MPs have been dealt with through the process, and then he comes to make an emphatic statement that you need to come to me first to get my order, which means he's saying that even in where he's providing information, those people have only become amenable to the process because he had to issue an order allowing it. That does not sit well with your interpretation of what the law is.
Sam, great. Let me say this. So as far as I'm aware, to the extent that I don't know the details of all those 13 odd cases, I'll reserve a bit of judgment, but let me also be emphatic that so far, I don't remember any instance where it's been reported in the media that an MP was caught slapping somebody or an MP was caught running red light and all that. So far, I haven't heard. You may, if you have any, we can look at that. Yeah. So my main point is that letter was written in the context of an MP who was not caught in the very act of committing an offense. If he had been arrested in the very act, all this cannot arise.
Okay. So the let's bring in the Sosu once more, and we need to conclude this. Yeah. And again, I need to emphasize, sometimes in this country, we obscure the issues, and the most important things, we leave them. Yeah. This matter has come up over and again. When you are discussing it, it is not because somebody wants Sosu arrested or anything like that. Yeah. Listen to the content of the discussion, and let's benefit from it. Now, we would now say there were 2 attempts of arrest. Yes. The initial one was when he was in the process of the demonstration. He says the demonstration was almost concluding or had almost concluded, but he was still there at the demonstration. That's where he says his constituents rescued him from the arrest. Then they decided rather to give him an invitation. Then the speaker was written to, and speaker refused to release him. The speaker says he's not available because Parliament has started its sittings. Right. Is that the right thing for the speaker to be doing?
Yes. Okay. So in this particular instance where they have written to Mr. Speaker regarding his the availability of the honorable member, all right, that is the proper context within which Article 1182 kicks in, because now, I mean, when he was, they attempted to arrest him on site and failed. Okay. In fact, even on that day, I think we're having a caucus meeting.
Yeah, he told them that after that place, he had 2 meetings of Parliament to attend to.
So we are having a caucus meeting, and he came to the caucus meeting. That was the first time he came and briefed us. But the situation where he's now in Parliament, and then they are seeking to arrest him, and they write to Mr. Speaker, that is the situation where 118 properly, kicks in. And I'm very happy that, Mr. Kwebu drew our attention to the 1965 Act, okay, because I believe that Mr. Speaker's, contention that there has to be an application to him is based upon an interpretation of that, statute, Section 20. I haven't read it, and I don't even know whether, as he is saying, I don't know whether it has been repealed or it's part of the Green Book. But I also needed
it's part of the Green Book.
Okay. Yeah. I also needed to underscore one point. Just to let viewers understand that there has been a practice and procedure that has been established, not by this speaker, but by previous speakers. And in fact, it was, the Right Honorable Michael Quay, being himself a lawyer, who stood strongly, for that practice and procedure, which is that you write to Mr. Speaker, and then Mr. Speaker makes the MP available for interrogation. And he actually insisted that the interrogation must take place on the precincts of Parliament. Right. Okay, so, and
Mahama Yarga testifies that he's had several locations. They've come to the
I can give you a live example. We know that some of our colleagues are being prosecuted now in respect of Sagleme. Okay. All right. I am on record as a lawyer for, Honorable Collins Dauda, all right, and then one of the former ministers of, of Works and Housing. Myself and Eduji Tamaklo, my junior partner in Chambers, often went to speakers,
lobby.
The speakers' conference room for the interrogation to take place. Okay, so we accompanied them, met the police there, the interrogation took place, and then the police will go back and then, write their report.
Do you understand that? Do you say that is a different situation, like Martin is trying to explain? And I had asked myself when I saw the speaker write in absolute terms, I had asked myself, imagine the speaker was conducting the business of the house.
Yeah.
And there was some scuffle in the house.
Right.
And say somebody pulled a gun to shoot at the speaker.
Right.
And the police was available or the marshal had to help and do things.
Let's say that he shot someone else other than the speaker.
No. Will there be a will the speaker say, hey, you can't touch that person until you get my certificate?
Okay. Yeah. So you see, it's a very interesting point that you are making. All right. If the crime is committed, you know, I mean, on the precincts of Parliament, you know, in the face of Mr. Speaker and, you know, other members of Parliament, the question then becomes whether or not the police can instantly arrest.
Or in the face of the police. Or in the face of the police.
You know, the police are not allowed on the precincts.
No, I'm talking about outside of Parliament.
Outside
of the Parliament. A member is attending.
No, I think
it's on his way to Parliament.
Okay.
And then he commits a crime in the face of a police person.
No, in that case, if he's on his way to Parliament, then 117 kicks in.
Really?
Yes, 117 kicks in. He cannot be arrested.
On his way to Parliament. So let's look at it this way. At it this way. On his way to Parliament, there's a scuffle. He shoots somebody dead. We should allow him to go. We should get a certificate from Speaker.
Yes.
The immunity.
Really?
Yeah, the constitutionalization of that immunity also has legal consequences.
Yeah.
All right. So you cannot effect an arrest that is unconstitutional.
Martin disagrees with you on this.
I don't think so.
I also disagree with him on that aspect.
He says if the offense is committed in flagranto delicto, you must be arrested. In fact, in the framers,
if I may come in,
just let me point him to this, then we can continue there. The framers of the Constitution, in the one that I referred to in the 1968, they referred to this and said, in paragraph 433, that in order to ensure that members of Parliament are not prevented from participating in the work of the House, they should be granted immunity from arrest and detention while they are traveling to and from Parliament or while they are attending Parliament. This immunity, however, should not be made to cover serious offences such as treason, sedition, and felony, nor apply to offences in flagrante delicto.
Yes.
Meaning, we have seen you committing it.
Well, I would have preferred that we referred to the Committee of Experts report because that was what informed the content of the 1992 Constitution.
Right.
However, if the provisions in the 1992 Constitution, are impari materia, if they are the same as those in the 69 Constitution, then we can say that this analysis will apply because the Committee of Experts also referred to the report of the Commission, for the Constitution of 1969 in crafting this. And in some cases where they thought that there was no need to change the substantive content, they just simply lifted them and added them to the Constitution.
All right.
So again, it's a question of constitutional interpretation, as to whether in those circumstances, we can go back to the 68 report and say the framers did not intend that, a felony be covered by the immunity or the commission of treason be covered by the immunity. Of course, treasonable acts, are acts that are intended to overthrow the arms of government.
And he said felony to felony.
Right. Okay, so in those circumstances, would you now wait? If for instance, Mr. Speaker could be part of the conspiracy to overthrow the arms of the government. So would you now wait?
So you are changing that? You are changing your position on that?
No, I'm not. I'm just simply saying that theoretically, if we were to go back to the analysis of the 68 Commission, then our interpretation of 117 should change. If that was the intention of the drafters of the Constitution.
But without that, your position is that you still need the Speaker's permission.
If he's on his way to Parliament, he enjoys that constitutional immunity.
But you said a while ago that standing in Parliament itself and engaging in the proceedings of Parliament, if somebody took out a gun and was going to shoot, you do not need to say that we need a permission before. No. You are standing in the premises of Parliament and then you are committing an offense, right? As I was saying, the police cannot come to the presence of Parliament. It is the Marshal of Parliament under
the authority of Mr. Speaker who will arrest that person.
When the marshal arrests the person, what do they do with them?
Oh, the person is then handed over to the police for purposes of, I mean, there will be discipline in accordance with our standing orders, first of all. But both the Constitution and our standing orders are to the effect that the fact that you have been punished under the standing orders is no bar to criminal proceedings. So you'll be handed over to the
Speaker will not give the marshal permission to do the arrest. The marshal must arrest.
Yes.
And once they do, they hand over to police.
Yes.
Okay. Quickly on that, and then let's see what we do.
I mean, if you allow me, thank you very much. I think that it's important for us to remember that the immunity conferred under 117, 118 is what lawyers call procedural immunity.
Okay.
It is not substantive immunity, and there's a danger to confuse them sometimes.
Okay.
In other words, nobody in Ghana, members of parliament inclusive, are given immunity of any kind in terms of the substantive laws of Ghana. In fact, even the president has procedural immunity. Procedural immunity means you have immunity unless certain processes are gone through. In the case of parliament, you have immunity, if we should agree with the arguments that Honorable Dominic Ayine, for example, has proffered, you should comply with the processes of going through the speaker before you're able to complete and effect an arrest. It is only procedural. It is only the process, not the substance. Now, in this case, I would like to just also draw attention to the fact that we need to understand that there are two kinds of arrests. We have arrests that are originating authority of the police to conduct arrest on their own. They don't need anybody to activate them. And then we have arrest pursuant to the warrant of a court. Yeah. If the court issues a warrant, what they simply do is that they shift the locus of authority, and they also then shift blame. So, for example, if the police conduct an arrest and the arrest turns out to be false, under the Constitution, the person can sue the police for compensation. And the law says that the officer involved will have to personally compensate.
Right.
If the court issues a warrant of arrest and the police effect an arrest pursuant to that, if the arrest turns out to be, the basis of the arrest turns out to be false or wrongful, you can't sue the police because they have acted pursuant. So it shifts the locus of blame and the locus of authority. Okay. But that doesn't imply that the police of their own cannot originate the authority to arrest. Now, what that means is that when the police originate their own authority, when the police commence an arrest process on their own, without the originating authority of a court, for example, that is not a process.
That is not a process?
No, that is not a process.
Okay.
It is an arrest.
It is an arrest, but I'm saying it is not, when we speak of a process, when lawyers speak of process without qualification, what it means is we are speaking of judicial processes, documents that are related to the judiciary. The police arresting someone is not deemed a process, in quote, as a term of art.
You are still confirming your interpretation of Article 117.
Correct.
That it doesn't apply here.
Correct.
The police
and if you extend it to the Parliament Act,
have liberty to just arrest.
If you extend it to the provision quoted by my colleague Martin Pebu, the issue of the Speaker having
from
to come
Section 20 onwards of the Parliament Act.
Correct. It's still very much akin to processes. Now, the reason for this, and you see the examples you are giving, and Dominic explained some of the, sorry, I'm a good friend.
No, don't worry.
I call him Dominic, we are good friends.
Yes.
But he's an honorable member of parliament, so Honorable Dominic Ayine.
Breach of privilege.
Yes, forgive me for that. Breach of privilege. So if the examples you are giving, an example that came to mind is this. If, for example, two members of parliament engage in a scuffle, or a member of parliament and somebody, and in fact, given recent happenings in parliament, that is not beyond the realm of possibility. That can actually happen. If two members of parliament are involved in a brawl and one stabs the other, for example, and we have a major incident of an attempted murder or whatever it is on our hands, we are saying that if the police are immediately informed and they make their way, the marshal arrests or the marshal brings them under control and the police have to come in and complete the process, the police have to get the speaker. If, for example, the speaker is not on hand, the police cannot go through the process, complete the process of arrest unless they've gone through the speaker. That is problematic. The power of the police to arrest, as I indicated, originates from Article 14.
Okay.
And if you add that to the Criminal Procedure Code, what it means is that even on reasonable suspicion, they don't have to wait for offense to be committed in flagrante to be looked to. Once they have a reasonable suspicion, they can commence and effect an arrest. And I think that the tendency to want to restrict this, and if you allow me 30 seconds,
yes,
I promise.
I need to go to SN Dankwa quickly so that we take a break.
But 30 seconds, I mean, the 1969 provision that you referred to, the Committee of Experts, the Commission, there was a historical basis under the 1960 Constitution. The powers of the president under the 1960 Constitution were excessive.
Exactly.
And there have been criticisms of the president having exploited and abused and all that. So the 69 Constitution Commission was clearly liberal under that. And were trying as much as they could to avoid a circumstance or the tendency in which the executive, with the powers of police, can literally manipulate the legislature. Okay. So all these variables sort of played out, and that probably reflected.
Yes. And
in their
what some citizens have been asking, and Dominic, if I can get briefly on that, then I go to the venerable SN Dakwa. Members of Parliament, you are always on your way to attending to or returning from Parliament. Even in your sleep, in your bathroom, when you are in church praying, you are doing parliamentary work. Then, are you not abusing this law such that you can never be caught under, you are always living in privilege? And sometimes, even when you are on your recess, we are always told that you are attending some meeting which is under Parliament, and so nobody has access to you until, if this process has to be followed, Speaker says, go and deal with the person.
Well, I come from a school of thought that says that, all of us interpret the Constitution.
Right.
Ordinary citizens, state institutions, officials of state, and so on. We interpret the Constitution in the course of the execution of our daily tasks and living our lives as citizens.
Right.
Until such a time that there's so much confusion about or there's conflict with respect to our various interpretations of the Constitution.
Right.
Then the only, arm of government given the power to settle the dispute then kicks in. That is the Supreme Court in this case. I think that the overextensive interpretation of the provisions, all right, it's a kind of attempt to self-preserve, okay? Because look, I mean, let's face it.
When you say overextensive interpretation, you're talking about Parliament.
Yeah, no. I'm talking about individual MPs or the MPs as a body thinking that even when they are in their bathrooms, as you have, jokingly referred to, they are, acting under privilege. All right. It is because we have a history that we cannot, run away from, which is the tendency of executive abuse, of power, the power to arrest and to detain, all right? And most of the time, and as Prof pointed out much earlier, usually it is the opposition that is in fear, living in fear of being, arrested and detained. And
particularly this Parliament, which is divided.
That is so.
If the executive wants to abuse the power, they just need one MP out, then they can get a majority vote.
I gave that example on your Super Morning show yesterday. And I said, look, in a very evenly divided parliament such as now, if there's a critical vote to be taken, all we need is an instruction from the president to the IGP to damperize, damperize 10 members. Okay. And then the vote is won. Without, so
you don't need 10 members. I remember, is it in 2012? The police had invited, is it Kennedy Japan?
Yes.
He attended to them, and then they arrested him.
Yes.
And then
I think that was when he made the statement
those
about
comments,
comments about
which eventually bordered on misdemeanor rather than those charges.
Which also means that the police must start respecting these specific authorities, like invitation, like if you invite someone, 90 out of 100 you don't arrest him. He's a person of interest.
Right.
But if you invite people and you arrest them, then the invitation becomes something of a trap.
Right.
And people complain about that.
Right. That's why Justice Dennis Ajay will say, as lawyers, exercise your discretion on this, because often the invitation will be turned into arrest. Yeah. So why don't you let them arrest them so you can exert your rights when you are being arrested? Because when they are inviting you, you can't talk about any right. Okay, let's go to SN.
Well, hopefully things will change.
Let's go to SN Dakwa. who is on with us briefly to give us some insight into his time with Parliament and how all these things were done. It must be stated now that the police have decided that they don't want to take the blame for anything. So they have gone to the court. Wow. And the court has issued a criminal summons. So now it is the court that is chasing the MP, not the police. The criminal summons acts in a funny way. It says it can be served either through the clerk of parliament or the head of department of the public service. And members of district assembly and so on enjoy the same immunities like MPs. You can't serve them when they are on their way or they are returning or they are doing their job. But you could also take it to the person's house, ordinary resident. If you find them, give it to them. If you don't find them, you can give it to someone of apparent age of 18 and it will be deemed as service. If you can't find somebody there too, then you can post it or paste it on a conspicuous place within the premises. Or you can send it by post, as in postal process to them. And they will have to show up. If they don't, they can decide that they will send a lawyer, just write a letter to plead guilty, and the case will be dealt with without their attendance. Thank you very much, SN Dakwa, for your time. Help us briefly in the history of this parliament. You have served in the first to the fourth parliament. Has this issue always been this, as it were, heated? And how has it been resolved?
Well, thank you very much. Let me say that this immunity and privileges for members of parliament was given to ensure that members are not restricted from their performance of duty in parliament. And so, in order to prevent arbitrary arrest of members of parliament by the executive or the other authority, they say that when a member of parliament is attending meetings of parliament or going out, you cannot, arrest him, so that his duties cannot be restricted. He has to come to parliament to perform the duty for which he was voted. But it seems to me that other people take it that the immunities and privileges of members of parliament are licensed to commit crime. Let's make that emphasis clear. We are supposed to prevent crime, to ensure peace and order in the society. And therefore, if a member of parliament is caught in the act of committing crime, I think he can be restrained, taken, and then inform parliament that this member was in the process of committing this and we have got him in custody. But the speaker must be informed because he wants to ensure that members are able to attend parliamentary meetings, sessions, and so forth without any hindrance. And especially at this time when membership of the two sides are almost or are equal, if an executive does not want one side to carry a vote in favor of another one, they can manipulate to get some members of parliament and say that he is under arrest for certain crime. You see, especially when the membership of both sides is 137, 137. And I give you a typical example of this bill, is it bill or motion which is coming before Parliament, that is about homosexuality. You see, the sponsors of these people who want to ensure full attendance so that they can vote for it.
That's right.
The other side also, who are opposing, they even want about 2 or 3 who do not want the bill to come. In this case, you see, the Speaker must ensure that all sides are protected. Remember, there's no way you can restrict somebody from coming to Parliament to perform his duty in this way. So all that I can say is that many members would like to ensure that all sides are present in deliberation, especially about controversial issues. All sides should be present, and not a single one be absent because the executive or other authority is trying to use the other one to the advantage of the other one. So I would say that, first of all, immunities and privileges of members of Parliament are not license for committing crimes, but to preserve peace and to ensure that the work of Parliament is impeded, is not impeded, so that we can have smooth peace in this country.
In this case, we have discovered subsequently that the charges against the MP are actually misdemeanors. That is to say, not exactly any serious offenses.
Yeah.
Do you think misdemeanors must be the reason that an MP, will not be given the opportunity to have the Speaker release them?
Well, perhaps, if I can say anything, we have this bill before Parliament. That's homosexual bill, which many Ghanaians hate. But others also want to have it because they say it will protect individual freedom. So, if the police on its own do not inform the Speaker that this is going to, this man or this MP has committed this crime, therefore he may be there for a long period when this particular bill, which concerns everybody in this country, is about to be passed.
Okay.
So it would have been prudent for the police to inform the Speaker that this is what has happened, and we need your permission we need your permission to carry out this in accordance with Article 117 or 118.
How should the two get to work together? Because I hear some suggest that this thing about go to court, if it gets to the court, the interpretation which will be binding might not help the cause of Parliament and the MPs. So the better way is to mutually agree on the protocol nicely so that you don't have a court giving an interpretation that will take away the manner in which the MPs are looking at it. If the Speaker is written to and he says, I'm not going to release him, how should they cooperate to avoid some of these things?
Well, actually, if the Speaker says that he's not going to release, he must have very good reason for doing that. In fact, I worked with this Speaker for a long time, and I know he's a very reasonable person. If he knows that there's something going to happen very soon, perhaps if he allows him to go, the police will also not allow him to come early to do the parliamentary duty. So we know the Speaker's reason. The Speaker's reason is that they have started their work from now until December. Mm-hmm.
Yes, that's it. That's the reason.
Oh, that because we have the last one. I strongly believe that the Speaker is quite aware of their agenda for the remainder of the year. And he knows that perhaps very, very important bill or something that will affect the whole nation is around. That's why it's not allowed that.
Okay.
I don't think it can be capricious.
All right. Thank you. Thank you very much, S.N. Dakwa, who has served, elder statesman, we should say, who has served both from the first to the fourth Republican Parliament. And this is where we take a break. I read just one small message as shared by H. Kwesi Prempeh, and a part of it he says that, Professor H. Kwesi Prempeh, he says that in democracies across the common law world, it is fairly common for MPs to be arrested, charged, prosecuted, even convicted. And while it makes sense that the Speaker would be notified of an MP's arrest, charging, prosecution, or conviction, the law and practice in these matters typically do not give the Speaker a mandatory gatekeeper or pre-clearance role or veto over the decision or actions of the law enforcement authorities in respect of an MP. The one privilege of an MP that may not be questioned by anyone in any forum outside of Parliament, including in a court of law, relate to speeches made or matters said by an MP in the course of the business of the House. We'll be right back. You're welcome back. This is Newsfile. It's your most authoritative news analysis show. Unfortunately for the law school and legal education reform issues, we can't do beyond 5 minutes for it. We apologize for our next set of guests because it was not intended that we will discuss this matter for that long, but it got very interesting. And it is important that we bring some finality at our end to it. It does appear that until there is a pronouncement from the Supreme Court or there is a certain agreement between the police and Parliament, this matter will continue in the manner that it keeps coming up. Kaswa Brantier, Andy, Larry says that unequivocally the standing orders and the ultimate privileges of the parliamentarians should be reviewed. The impunity and abuse of power privileges are highly appalling. Equality before the law is sardonic and purely shenanigans in the country. K. Amofa, you need to protect your MPs too, you know that. K. Amofa says that the problem with the Speaker's decision not to release Honorable Sosu is worrying under the charge of criminal nature. Well, elsewhere they have stated how long you can decide not to, you are attending to and this, and they have decided it's only maybe 5 days. Beyond that, the Speaker can't do anything. Papa J, LACM official, says the Speaker needs to be informed and be notified of any intention or arrest of any MP. It is very important. Nana Yao says that, he's replying, LACM says that the police is not powerful, but the law is. If a celebrity has been arrested in that same powerful process by the police and they obeyed, what prevents a parliamentarian from doing so? Don't we want the police to work anymore? And then Musa Abattoir says that the Constitution is clear on what the police should do. Unnecessary tension in public domain isn't helpful. Separation of powers, which indicated that Speaker of Parliament is third in command. Therefore, police must accord him with the needed respect. Proverbial tutor Kofi Amwa said, did the police drive on good roads to go witness the demonstration? Unfortunately, because of this, the purpose of the demonstration has been lost, whether those roads are being fixed. We've just been told by some reporters that they've gone there and seen that contractors are back. I mean, why were you waiting all this while to fix these roads? We only have to fix the country together, and it will be practically impossible if we will use each other against ourselves. Never ask your silence MP for roads. Charles Rekurobe says, all roads are leading inexorably to the Supreme Court. Parliamentary privilege. Prince Henry Koforidua says, the police needs the legislature, same as the legislature also need the police to maintain peace and order. We don't have to be fighting each other. And finally, Eliasu Intamale says that the immunities enjoyed by the MPs have limitations. While the attempt at shielding him, I couldn't agree more with the police to seek interpretation on the above issue. Thank you. Now, like I said, I will take just about 2 minutes each from you, straightforward. What should be the way forward for legal education in Ghana? 144 students is what has led to all of this. They said they made a 50% pass mark, and later they said they discovered that the school is saying that you must make 50% pass in the 2 sections of the exams that you wrote, and not just 50% cumulatively. Now, they have been trying, things have not worked, so a majority of them are in the court. Whilst that was happening in the course of the week, Parliament passed a resolution. It appeared to be unanimous, directing the Board of Legal Education and the General Legal Council to admit them and to expand legal education. Some MPs, 2 of them, Nelson Dafiamapo and Francis Xavier Sosu, are also sponsoring a private members bill to expand the access. And they are also asking that the Chief Justice and other Superior Court judges who are on the General Legal Council should be removed. What's the way forward? Start with you, Dominic.
Well, I think that the reform of legal education, especially at the professional level, is long overdue. I remember as a Deputy Attorney General speaking on behalf of the then Attorney General in 2015 at the Bar Conference in Kumasi. The Attorney General made a call for the reform of legal education. Somehow or another, that didn't happen, prior to our exit, from office. But we in the NDC are still committed to that position that we took, that there is a need for a comprehensive reform of legal education that will, increase access without compromising quality. And the two are not necessarily, how will I call it? And in conflict, okay. Because you can actually increase access and then maintain, quality in the provision of legal education. So our position is that we allow the law faculties, such as professors, school, UPSA law faculty, to run the professional law courses, and they should be limited to what is needed for someone to practice at the bar: civil procedure, criminal procedure, the conveyancing and drafting, and then ethics, advocacy and legal ethics. Okay, and that these should be run by the faculties as clinical, these legal courses, and then there should be a national bar exam that is written by all persons, certified by the faculties as having, done the clinical legal program. And then they are called to the bar. That way, you do away with this whole notion of lack of, physical infrastructure to accommodate, a large number of students and so on. And something, that in our region, Upper East region, okay, together with the state attorneys, we don't have up to 10 lawyers. So the whole idea that there are too many lawyers in the country, is not well founded as a matter of fact, because I think our situation is even better than Upper West. Okay, so I think that in a nutshell, the overhaul of the legal, the legal education system, especially at the professional level, is long overdue. The bill that Honorable Sosu and Dafiamapo brought is one that is meant to amend Act 32, so it's limited in scope. But I have been working on one myself, pursuant to the 2015, the 2015 position that we took in Kumasi, and I am supported by the Honorable Muntaka and then Honorable Patrick Boama, all right, on the the MPP side, right. And ours is a more comprehensive bill that will also be a private members bill that will be submitted, early next week to Mr. Speaker. Right. So definitely, we are, garnering support for the overhaul of legal education in Ghana.
Right. And you just mentioned something. In the whole of the 5 regions up north, you have 39 lawyers.
There you are.
39 lawyers.
That must include the state attorneys, because
Yes.
usually when they count the lawyers,
Yes.
they count the state attorneys.
Yes,
In
and
the
in
region.
the Upper East, our place is more specific. You have only 14
Okay.
who are serving a population of 1.3 million. But, Prof, you are training the lawyers. Is this not a question of quality? And sometimes it looks like we are talking, but we are not conducting surveys to inform what we need to say. Is it really the problem with Ghana? Because I've been reading a survey that was done in Kenya, and it's not impressive at all. In July 2017, you had 2,018 students who sat the exam, and you had 783 who passed. And then in July 2018, you had 2,097, 666, 67 passed. So there was 39%, 32%, and then 2019, you had 2,178 and only 846 passed. That's 39%. And the survey says that students perform better in a particular setting when they have the opportunity to have tried the first time. Then they begin to know all that is the requirements that is going on. The research also says students with better high school grades are found to have gone all the way to do better in the law exams. So it's the quality. How are you churning out? They are actually suggesting that people should have the opportunity to do pupillage before they sit the bar exams.
Well, various suggestions have come up. Some are even recommending that we should have mandatory national service. It used to be the case, and they took it off. Mandatory national service, so people mature in.
You used to need a first degree first.
You need to, yes, but there used to be a requirement that after your LLB you needed to do national service before you go to the law school. Some have argued that that period allowed for some maturity. In fact, I can tell you that from our own trend analysis within law schools, the law schools I've been in, from our own trend analysis, you can tell that students who have first degrees tended to do well in certain areas of particular subject than students who didn't have first degrees. Right. And students who didn't have first degrees, also, in other words, students who have first degree tended to have maturity characterizing their answer, and students who didn't have first degree tended to have better industry. Better industry in the sense of they were younger, they exerted more, they were able to study for longer hours and all that. The long and short of all these is that we have a problem with legal education in Ghana. Nobody can dispute it. The second thing is the General Legal Council for the past 5+ years, number of years, have been embarking on all kinds of reforms. These reforms have had various degrees of successes, and it's imperative that we actually streamline the reform properly. I don't think that we've done as well as we could have done. There's a lot more room for improvement. But I worry. I worry about politicians and political participation in educational reform. Now, I have said it's not just for legal education. I think generally, because political pressures tend to exert certain influences that often are counterproductive. And I'm just saying this because my very good friend, Honorable Dr. Dominic Ayina, sitting here, he has a constituency. The constituency exerts pressures which may be otherwise than for the rational good of a particular reform. Their interest is, let our sons, let our daughters become lawyers. They're not really interested in the mechanics of that. Just help us get there. So when you have parliament, when you have political actors taking the forefront of legal educational reform, including parliamentary directives, while these may end up unintendedly achieving good results, I think that in the main, they tend to be counterproductive. So I think that one thing we haven't done is we haven't done the concerted effort of reform. Deans of law schools, law teachers, the Bar Association, these three entities in particular have not taken active role, the front seat in legal educational reform. The people who produce the people who hold the Bachelor of Laws, these are the faculties. But very often they have been consulted after the fact. They are hardly consulted before things happen. And I can tell you, that the proposed removal of the Chief Justice from the General Legal Council, it may not necessarily solve the problem at all.
Yeah.
You know, some people have questioned why judges and co should be in the General Legal Council. But the Chief Justice, and speaking personally about the current Chief Justice, I was privileged to have actually been with him on some, rounds across the country, doing vetting of law schools, reviewing vetting. I think one thing I can speak for him personally, as far as legal education is concerned, is that he's extremely passionate about quality. It is part of the reason some people think he's hardline, because I think the inspection that we did across the country.
His children didn't pass.
Correct.
Yeah, and
and they're out of the country. That should tell you something. Look, the inspection we did across the country, I think, may have exposed him to some shock.
Okay.
And that shock may be influencing his reaction. Yeah. Because to be honest, you go to some places and you can tell that there's the desire to run legal education, but beyond the desire, there's nothing.
Yeah.
No facilities.
And so we have a problem. And some people say this. You are mentioning figures from Kenya.
Right.
The professional courses such as ACCA, the failure rate is even more atrocious than this. The difference between this and legal education is that in the case of legal education, you find them in one space.
Right.
And so when people fail, you see it.
All right.
So nobody should get me wrong. I support the additional admission of students who pass. Anybody who pass must be admitted. I support the expansion of legal education, access and equity. I support the fact that things need to be done.
Okay.
But one has to be careful not to create another problem as we try to solve one.
All right. Thank you so very much. Unfortunately, I suppose that there will be a proper clinic during which we must interrogate these issues a lot more. Thank you so very much.
I can say, here on your, if you will allow me, that the Dean of the University of Ghana Law School, Professor Atuga, is organizing a conference, a kind of global conference on legal education in December. Right. And he has graciously invited me to be part of a panel, including Asan Kuma and a lot of other senior lawyers. So, thank
you also very much. My guests for the first segment have been Dr. Dominic Ayene, who is MP for Bolga East and former Deputy Attorney General and Minister for Justice. Professor Kofi Abochi is Dean, UPSA Law School. Martin Pebu joined us earlier. He's a rights activist, he's a lawyer. And then statesman SN Dakwa, former clerk of Parliament, who has been with the first to the fourth Republican Parliament, joined us. Thank you also very much. I have Dr. Gideon Boakon, spokesperson and aide to the Vice President, joining me. Professor Samuel Chinibua Kodia, senior lecturer at Gempa School of Technology, joining, and also Godfred A. Bokpeng, professor of finance and economics, economist, University of Ghana. They'll join us. My apologies to you, gentlemen, once again. We'll be right back. Professor Abochi will still be with us.
Starting next year, ladies and gentlemen, every newborn child will because we are linking the births and deaths with the NIA and the Ghana Health Service, every newborn child will within a month be issued with a national ID number. And so when you are issued at birth, you will have your national ID number, and that will be your number until death. But you can only be issued a card when your biometrics are fully formed. That is after you are 6 years old and going. Then you will get a card. But for now, you will have a paper card to give you your national ID number, which you will use all the way in life.
Right. So you've just been listening to Dr. Mahmoud Bawumia, the Vice President, and he has been speaking on transforming an economy through digitalization and the Ghana story. I will admit that I have been surprised to hear some amount of negative commentary because it will seem as if it's a good path to building a country in a very sound way. So let's begin to take what it is that makes it important to look at the economy through this way. So, Gideon, I've introduced to you already. We don't have too much time. So let's begin to look at what the issues really are. Why is this a focus, so to speak, of the administration in digitizing almost every sector? Of course, there are questions coming up because some of the areas that he speaks about, people can't exactly see what he's talking about. They are far removed from it, or they don't really see it happening.
Yeah, I think government basically exists to act on the mandate that the people have given to her, and to exercise that mandate in such a way that efficiency is brought to bear and people's sufferings are reduced. Whichever way you want to execute the plan to achieve that result is the ultimate thing that you have to do as a government. We all agree with the fact that our public administration system and our society is fraught with a lot of inefficiencies. More or less, our system has become bureaucratic, red tape, and more or less serving as a detriment to business growth. And so we need to think about new ways of doing things to make sure we bring efficiency into our public administration systems, to spare growth, to reduce costs, to improve the system. But how do you go about that? You know, society and the world has evolved. We've evolved from the period of the first industrial revolution, where the focus was on steam engine, came to the second industrial revolution of science and mass production, the third industrial revolution of digital technology, and now we are under the fourth industrial revolution, where we are looking at the interplay with all of these revolutionary periods to ensure that we spare growth and then people become okay in life. This transition also comes with its own terms, and that is where digital technology comes to play. Today, because of the transition, we have e-procurement, e-marketing, e-business, electronic money, and we are talking about digital governance. If you are a government and you indeed want to move with the contemporary trends, you then have to think about the new ways things are moving and then make sure you adapt and then move your country towards that direction. That is exactly what we are trying to do as a government. I'm not saying that this is the first time any government has tried to pursue any digitization agenda, but it appears, though, that Ghanaians are seeing some re-energized effort into the whole digitization agenda. And the focus, overarching objective, is to make sure that our economic growth is spared, and then people can have jobs, you can have the opportunity to also bring down some of the problems that people face. After the Vice President spoke, many people have asked the question, how is this digitization agenda going to help the economy to grow and also going to make sure that people get jobs? I've heard somebody say, yeah, Pejuma was a digitization. They want to understand the linkage between digitization and a lot of the economic fundamentals and issues we're talking about. Theoretically, I mean, that is established from the seminal work of Professor Schumpeter in the 1930s and the 1940s, where you talk about the need to replace long-standing old practices with modern technology and systems that ensures efficiency and also create jobs and all of that. Yeah. That is why he talks about the creative destruction.
Yes, so digitization of the passport office, the ports, the DVLA, establishment of the Ghana government platform, medical drone system, all of these things, getting 15.5 million people on the Ghana card and expecting more by 2020. How does that translate? Unique addresses for 7.5 million properties in Ghana, along with street names and house numbers, which have been provided, and all of that. How does that address my bread and butter issues? How does that address my kinky that continues to shrink? I think that's a question people are asking.
Yeah, exactly. And people link it to how does it address the issue of exchange rate depreciation, inflation, and all of that. Right. First and foremost, if we want to talk about the price of kinky, price build-ups on commodities or goods and services on the market come from different angles. But one other area that people may also see price build-ups is the exchange rate exposures. Of course, if your currency goes down, your imports become expensive, and then the price is passed on to consumers, and they have to pay. But the question that we need to ask ourselves is to sit down critically as a country to see how we can get all these problems solved. One of the ways by which our exchange rate gets depreciated is the increasing debt levels that we have as a country. Why would a country go and borrow? Countries go to borrow because their domestic revenue mobilization is not enough to take care of the critical expenditure that they need to do. In this country, we're about 14.5% of our tax to GDP ratio. So we are unable to raise so much revenue to take care of what we need to do. Then the question then comes as to, if you don't have revenue domestically, you have to go and borrow from the international market. Once you go to borrow, and the payment is due for you to make, you need to change cedis to go and buy dollars. And that, of course, exerts pressure on your currency. Your currency what? Depreciates. Once it depreciates, your imports become expensive. Once your imports become expensive, prices of goods on the market also become expensive or increase. And that is where you have inflation. So you need to sit down critically as a country that if you want to reduce your debt, external debt, then you need to raise more revenue. But you cannot impose tax burdens on the very few people who pay taxes all the time. You need to increase the tax net.
So practically speaking, if you had before now, if you had only 4% of Ghanaians who had their TIN, and after the digitization processes, now you have, and the Ghana card processes and the mergers that have happened, now you have 86% of Ghanaians who have TIN. What does that translate into domestic revenue mobilization?
So what it means is that you have increased the number of people who potentially can file their taxes from 4% to 86%. So that is a broadening of the tax base. Because when you have a population where the number of people who are willing and potentially can file their tax is just anemic relative to the total population, then you cannot realize so much tax revenue. So this issue of broadening the tax net, the tax net is not like a balloon that you can stretch to broaden it. You need to put in place systems and processes to make it easy and friendly for people to file their taxes. So we have done this, converted all tax identification numbers to the NIA card number. And then also gone a step further to make sure that we integrate an app so that you can even file your taxes on your phone. Once you do that, you've solved a certain problem of the domestic revenue mobilization. And once you do that, and going forward, you're able to increase your revenue, domestic revenue. Your external borrowings come down. Once your external borrowings come down, the pressure on your currency also comes down. So you achieve some relative stability of your currency. And once your currency becomes relatively stable, your imports do not become such expensive. And by so doing, you're able to reduce inflation on your market. So people who want to understand the linkage between digitization and then economic development, this is basically what we are talking about. Then also, there are others who ask the question about how are you using digitization to create jobs? Yeah, Juma was a digitization, but I say, I mean, it's so open that because of the digitalization agenda we are doing, the mobile money interoperability, today, look at the volumes of trade that take place on Instagram and Facebook. People are able to have their products advertised, and these young girls who have come out of school, they don't have money to rent a shop or something. Their office is their car boot, is their hostel, is their bedroom, and they are able to ply their trade on the internet. And people are able to advertise products. People are able to see the products, show interest in them, order them, and pay for those products with mobile money payments interoperability. That is what technology and digitization is doing to us.
As we understand, mobile money transactions have done far more than bank transactions.
Exactly.
Just hold on briefly for me. Let me go to Professor Samuel Chinibua-Kodia. Prof, thank you very much for joining us.
Thank you, my brother.
Yes, and we apologize once again most sincerely that we have very limited time to deal with this. From where you sit, this digitization or digitalization agenda, how does it improve our economy?
Thank you for that, and thank you for your listeners. In fact, I'm grateful for the opportunity. Let me first say that we are far behind this. I must also say that I am academic and researcher, so I'm looking at it from academic perspective. We don't criticize, we critique. I must also say that I'm not a professor. A professor is sitting there in academic environment. If you quote somebody title wrongly, somebody can take it on. Please, I'm a doctor, I'm not a professor yet.
All right.
Thank you.
Thank you. the PhD is a long way. So that's a lot of work you have done. So we have to recognize that. Thank you.
Yeah, good. Yeah. Good. I must say that in perspective of this, I think we are far behind. Digitization, from what our Honorable Vice President has said, is more of automation. And if you look at technology transformation, that is far behind. Countries that have developed have gone beyond automation to artificial intelligence. In fact, not only developing applications as in this case, but actually gone beyond exporting intelligence knowledge. That is where income is being generated. Sadly, we have these applications, which are quite good. The terminology of infrastructure, technology, digitization infrastructure also is a bit problematic here. But most of the things you've listed in the report, I've listed all of them, about 17. I can say that they are all technology applications and not infrastructure. Cyber infrastructure goes beyond the application that I've listed here. So I'll say that. Yes, when it comes to digitization, of course, it's the order of the day. I'm currently on a project from Canada where they are looking at how they can use artificial intelligence to support public sector work. The first and the primemost of it is to cut down costs. Our brother said, government is spending a lot in terms of the way they do things manually. So bringing technology solution in here as automation, the first principle is to cut down costs. Sometimes in this country, because we are paid in month, we don't appreciate time. So today, I mean, some of us from village, you used to send money through people to your grannies out there, and everything will get to the village except your remittance. Yeah, you've been able to send money at the comfort of your home everywhere you are in the world to grannies. Fantastic. These are not things we need to trivialize them at all. Of course, we are far behind, but I said that a journey of 1,000 miles start with a step. So it's a nice move, and I think we are far behind. We shouldn't look at the negative of it. Look at the positives of it. Of course, there are challenges. Now, with your permission, I'll look at a few things that I need to draw my broader attention in terms of the advantages that we are checking, and I'll dip into what he has done. Me, in my case, I'll look at the issue of adoption and use, implementation and sustainability. That is our major problem in Ghana here. When the issue comes like this, one government is introducing it. Very good. So it's government A, everything, publication, they have it. How sustainable are these in terms of new government taking up? We have multiple projects, IT projects that has been abandoned because of change of government. Sometimes we forget that these things are state resources that went into it. Of course, we might not know the costs that have gone into it, except the addressing system that we knew that, I stand for correction, I read it from media, that about $2 million went into the addressing system. We'll come back to that. How sustainable into this should a new government take over? We also look at costs and returns on investment. So take the digitalized addressing system. It was implemented over 3 years ago. 2 million supposedly went into it. If it is private sector, you ask the person that, okay, this 2 million that went into it, what has been the return on its investment? Today, you and I and all of us sitting here, how many people share address with a GPS address? I tell you what, I went to GRA office at Adenta, a place called SDA Junction. There's this in there, to register a tax for a colleague. I was asked to draw. So I asked them, what is the purpose of GPR system that we have? Why should I draw a location to someone's office? But that is what I did. Monday, I was at one of the banks, Ecobank, to be specific. They don't accept NIA card. Vice President made us understood that now liaising with Google to integrate it with Google App. All of us here, we use Google App now. Now that people have come to accept Google location, when are they going to change our mind to GPS that we start sharing it? Today, if you enter your GPS system, will they take you to address? UK, US, you can type postcode and you get the address. You can type the address and get the postcode. my street.
Sorry,
my
are you saying that doesn't happen because we are using Uber, we are using Bolt, we are inviting people to our workplaces, our offices, and all we do is to just send them the address and they come straight forward. You don't have to suffer.
Sharing Google address. We are not Google location, not a GPS address. I don't know if you have tried it with your friend. You've shared your GPS address and they have come to your house before. You can educate me. I haven't done that, and I stand for correction if anybody has done it and got a good result of it. I have not gotten it. My house, the same street, opposite doors have different address, street names. Why? These are the things we need to query the system. We are attacking it. As I said, I am academic.
Okay. Now, Doc, just hold on briefly for me. Let me bring on Professor Bokping. Professor Godfred Bokping, thank you very much for your time, sir.
Yes, good morning.
Right.
And to our cherished listeners.
So from where you sit, looking at the bigger picture, if we have generated 7.5 million property addresses in Ghana, unique addresses, street names, house numbers, and so forth, if with the Ghana card, we are trying to do what we are seeking to do with it, and we have 15.7 million people on the Ghana card. A friend told me about how his Ghana card was used in the US when he flouted a traffic regulation, and they just swipe it, and all his details popped up. And he was able to pay his penalty and move on. What does all that mean to you from where you sit?
Okay, thank you very much. I think this is a laudable move, and I share with a perspective that is long overdue. In fact, others have gone far ahead of us. We are more or less at the basis of the digital transformation. That said, I think that there is huge potential from the steps that we are taking. If we also take time to address the technical issues underlining them, the procurement issues and the transparency and all of that, then we'll be able to translate the hypothesized benefit, as somebody would say, from theory into actual. Look at it this way. We have struggled as a country since independence to generate tax revenue. And one of the reasons, I think Dr. Boakun has talked about that, and it's all over the place. Property tax, we are not getting enough from that level, even compared to our peers. And the reason is also because of the lack of data that would enable you to do proper assessment and defend that. So if you are able to digitize that space, and then you're able to capture them in, you can raise proper assessment and generate the much needed tax, which is then good for development. We are not doing quite well from that point. Then it doesn't end there. The challenge we have is how do you link all of these things with the various agencies to ensure that people don't escape the net, right? Because the net tends to capture vulnerable people and the poor, okay? But the very powerful people who own these properties and all of that actually tear through the net and all of that. So, and also because of the huge informal nature of our economy, these are all steps trying to formalize the informal economy along a certain continuum. And something, let's put it within perspective. Nothing can replace digitization. Is the way to go. Studies have shown that the digital economy is going to grow faster than the traditional economy. What is the digital economy? There's a difference between the digital economy and the traditional economy. The digital economy is the economy that is based on the use of technologies and the economic output that arises as a result of use of digitization and all of that. That said, there is also a difference between digitization and digitalization. The first level is almost where we are converting physical document data into, let's say, digital formats. The second level is leveraging on that to improve business competitiveness and generating additional cash flow. That is where we are looking at it. Now, and you see, we are a bit behind. And even the African Union has actually recognized this under the African Continental Free Trade. So far, Protocol 1 has been negotiated, trade in goods and services. Protocol 2 is being negotiated, which has to do with competition policy, intellectual property, and all of that. Recognizing the importance of digitization, digital trade, e-commerce, the 13th Extraordinary Summit of Heads of State and Government took a decision to bring forward the Phase 2 negotiations, which pertains to e-commerce, digitization, and all of that. This is to recognize the role that digitization plays in this whole African continental free trade. So this is not something that even government should take to itself alone. We are looking at broadening the digitization and digitization agenda across private sector so that they can use that to take advantage of the African continental free trade. So for instance, as we speak right now, aided by Afrexim Bank, headquartered in Egypt, and African central banks, they have developed what we call the Pan-African Payment and Settlement System, okay, and which is to link the African market, because wherever trade flows, payment is important. So we need to scale up the capacity, the digital capacity of the Ghanaian private sector and the youth to be able to take advantage from that. Other than that, we'll lose out.
Prof,
when you look at the scale,
yes, Prof, when it comes to the Ghana being the first country in Africa and one of the few in the world to achieve the type of interoperability between banks and mobile wallets, one may understand that that permeates, and the beneficiaries, it goes to almost everybody. But when we are talking about, say, the Ghana card enrollment, and that's 15.7 million, and it is going to be accepted in 197 countries and 444,000 airports, 44,000 airports in the world by the first quarter of 2022. Is this not some, middle class life thing that we are improving rather than the other people, everybody? The majority, so to speak?
Precisely. That was the point my colleague from GIMPA was talking about, that others have gone far ahead. Others are talking about artificial intelligence, right? Distributed ledger technology, machine learning, and all of that. But I think because we didn't have this, and we have now started, it looks like great news for us. But I think these are also important building blocks that we can leverage on going forward. And we need to recognize that. And then build on that quite quickly. But beyond that, you see, the digital infrastructure underlining all of these things and the necessary investment, we have not done that. Exactly. And that is why my colleague from GIMPA was talking about the fact that it's more of the apps that we are talking about now, and that our tertiary institutions are not equipped with the necessary lab and the digital infrastructure to scale up at the level others are doing and all of that. Look at the row recently between US, UK, and Australia by certain marine, nuclear, whatever, and all of that. So France got angry because, you know why? Not that they care so much about the security of Australia, it's the money. The billions of dollars that they are losing that is now going to US and UK and all of that. So I think that there's enough room for improvement, and that is where we should. And I can tell you that our digital infrastructure as it stands now is incapable of getting us to the level of digital transformation that allows us to compete even at the regional level. I was going to make the point that if you look at the scale, Ghana is far behind even Libya, Mauritius, Kenya, okay, and even Nigeria in some aspects. So yes, we have made some recognition, and of course, I respect the perspective and the energy and the dynamism the vice president has brought on board. But if you look at it on a certain scale, we are still far behind, and we need to. And government need to complement and work with private sector to generate.
Now hold on there for me. So, Professor Bochi, and those of you who are not too familiar with Professor Bochi when it comes to matters of economy, I'm sure you have been shocked on this platform before.
Really?
Now, Now, like the two, TK, Doc, and then Professor Bokwing are talking about, that in fact, we are far behind, even in what we are beginning to celebrate as we have achieved. As far as they are concerned, these are modest. So if this is that important, what is it that we are supposed to do that we haven't done? If this will improve service delivery in the public, among other things, as we have seen is being talked about.
So the production, storage, and retrieval of information has been a problem in Ghana.
Okay.
Anybody can hardly dispute that. We don't produce information well, we don't store it well, and it's difficult to retrieve when we have to. And since data is the building block of development, and today data is the leading factor, and for the most important thing in the world today is data. And so since data is so critical in development, the production, storage, and retrieval of data cannot be underestimated. Some will add the syndication of data. The ability to synthesize data, the ability to produce data in one end and use it in another end, the systemic character of data, it's important. And I think that digitalization or digitization is an important factor in this regard. COVID has even further underlined the imperatives of the digital economy and the need for us as a country to go digital. I think some people may have complained about some fundamentals, and I heard the Professor Bokki and my former colleague at GIMPA also speak on some of the key things that we need to pay attention to. And I'll add that it's important for us to then pay attention to digital literacy. We cannot build a digital economy that is functional in the absence of digital literacy. Have we prioritized literacy, digital literacy in our schools? I'm mindful of your time, so I'm just going to quickly run on this. But have we prioritized digital literacy in our schools? Our schools are still teaching, there was this funny video that made around, not funny, but rather sad video that made around on WhatsApp some time ago about a teacher who was teaching a school, a bunch of kids in the village, about computers. And he had to draw it on the board. So in 20-something, our teachers are still teaching by drawing things on the board when they need to actually have these things in labs.
Right.
How many of our schools still have labs? And how have we prioritized digital education? We may be putting the cart before the horse, even though we are already late in getting that horse around in the first place, and therefore we can't even wait. So perhaps we've gotten to that point where we need to build the economy, but we have to build the skills alongside it. So skills training and the education and literacy. We need to also then work fundamentally on the question of trust. When mobile money started in Ghana, people were not quite sure what it was. And it took a while before it caught on. Nigeria has piloted what they call the e-Naira. And Ghana has just announced, I think, its intention to go the ECD as well. We can learn from Nigeria's experience. Nigeria is still suffering seriously from the e-Naira in terms of trust. When people are not sure of something, it takes a while before they warm up to it. The digital economy is important. It probably is here. But it's imperative that we build trust. The next point I'm going to mention is the question of the inclusion, digital inclusion. We still have a lot of places in Ghana that, frankly, are just cut off from anything happening. And the danger of further reinforcing this, when you bring a digital economy and a digital system, which many people, frankly, even the people in the cities, are not quite sure how to go about things. And then you have people who, frankly, are out there. Basic literacy is a problem. Access to basic resources are problems. They basically just get dislocated, and these people are cut off. So you create an exclusivity scenario. I think you were mentioning the question of elitism.
Right.
And that is where the critique of elitism may come in. It may be an unintended consequence of the digital economy. So digital inclusion is important. But the final point I'll make, and that's, I think, something Professor Bokwin also probably touched on, but he didn't probably mention the example I'll mention. The issue of systemic infrastructure. You don't just deal with the digital economy as an isolated scenario. There are supporting systemic infrastructure. For example, in a digital economy where electricity cannot be guaranteed, you will create more problems than we used to have with a non-digital one.
Right.
So if I go to the Registrar General, today even they are going digital, but a few years ago, they'll pull my file. And my file was a physical file.
Yeah.
And unless it's rained and the place
And your
is
file could get lost.
well, that could get lost.
Just like in the courts.
That's another problem. But unless it's rained and they cannot locate my file, they're likely to pull something physical. But if you go there today and the lights are off, it means that you have to wait. Because there's, whatever it is that they have to produce for you is stored digitally, it's stored electronically, and they can't pull it out. So the digital economy cannot be negotiated. It's an imperative of our time, it's necessary. I can't foresee how anybody could reasonably critique it. It's an important thing.
Right.
But if you do not build the supporting systems and infrastructure, if you do not create the inclusive environment, if you don't deal with the question of skills training and literacy, you may create an economy which may find itself insulated.
Okay. This is a message. This says that it's from PK in Elembele, and Dr. Boakwan, I want you to address that. It says, my take on digitization or digitalization in Ghana is this. In fact, it offers convenience, makes things easy and simple. But this government cannot outsmart Ghanaians now. Why couldn't the digitalization help to maintain our brothers and sisters who were working as NAPCO? Okay, so I don't know. I thought it was getting a certain direction, but obviously I don't know. Yeah, so I had suggested that, I had said that someone used the Ghana card in the US. I'm trying to confirm with my friend, but I understand it must have been the person's ATM card rather than the person's Ghana card. How do you address the issues of some banks not accepting the Ghana card? My bank, ABSA, they accept the Ghana card, but we know EcoBank, is it SGSSB, they don't accept it.
Yeah, I think first of all, the consensus around this table is that digitization is good for us. We are lagging behind. We need to accelerate.
It's inevitable.
The rate at which we're even digitizing and digitalizing our economy.
It's slow.
And so that's agreeable. On the issue of the Ghana card and its acceptability in certain private and public areas in the country, I think it all boils down to the integration process. After having the card, you need to go that step forward to make sure you integrate it with the key agencies and then also the private sector to make sure its acceptability is high. So we've started the integration process. With respect to the integration with the bank database, that is not yet complete, and that is why some banks are not accepting the card now, depending on what they think the card can be used for at their bank. It's not just the Ghana card. Even the previous election, 2020 voters ID card, some banks don't accept it because the integration process with all of that have not been completed. So that is a step where the
Ghana card is becoming the passport, why should we have this at this time?
So it's in phases. That is the phase we're in now. We've started integration with the National Health Insurance Card, integration with SNIT, integration with DVLA and the insurance companies and all of that. So that part with the bank's database, and mind you, the bank is also a private sector. There are a lot of technicalities and issues that go on with the integration with the database of the banks, and so that is where we are now. The banks will have to have some level of assurance, cybersecurity issues, and then make sure everything is well and properly done before that integration is completed. So far as the integration is completed, banks will begin to accept. We cannot have a Ghana card that is not acceptable by banks. You understand? That is so critical because part of the reasons why, and part of the economic solutions we are seeking to have with the Ghana card is the impact on cost of credit.
Right.
So if we are not able to integrate the bank database, then the objective of using the Ghana card, the digital property address system,
so
to reduce the risk
EcoBank, I'm getting the
borrowers.
information that they have started this month accepting the Ghana card.
Yeah.
And the reference I was also making about the card, it was rather the driver's license.
Okay.
Yeah, the DVLA. But that is being integrated into the Ghana card.
Yeah.
The Ghana card all other cards are being integrated.
We want to subsume everything into the Ghana card to make it one. So we have a unique identity. So the identity of people will then not become questionable. Okay. Let me touch briefly on the issue of the Ghana Post GPS. Yes, I agree.
Some 30 seconds.
And Prof. Abochi talked about digital literacy. When you put in a system and people don't really get to understand the usefulness of it, the adaptability becomes an issue. So we realize that asking people to download Ghana Post GPS app on their phones is not something that everybody may want to do. People see Google Maps and WhatsApp user-friendly. And that is why we've gone a step forward to have discussion with Google Maps. And Google Maps has agreed that we can input all our digital property addresses into Google Maps, and that becomes easier for people to go to Google Maps, key the number, and then it pops up and they're able to get direction. I think the next forward going is also to talk with WhatsApp to make sure that we integrate with the WhatsApp, because people find it so easy using WhatsApp to send locations through Google Maps and all of that. So it's a stepwise procedure. You get one thing done, then you move on. And it's also technology. And as we go along, things may evolve, and we have to change strategy, we have to upgrade. And that is why today we have, WhatsApp and all of that upgrading themselves to.
So you are not saying we have arrived?
No, we've not arrived. In fact, like we all agree, we are lagging behind, but within our setting and our scope. This is why we have come to and why we need to
I want to thank you so very much, and once again apologize for how we have to manage with very limited time. Dr. Gideon Boakon, a spokesperson and aide to the Vice President. Dr. Samuel Cheneboa-Kodia, a senior lecturer at Gimpa School of Technology. Professor Kofi Abochi is Dean, UPSA Law School. And Professor Godfred Bokpeng is Professor of Finance and Economist at the University of Ghana. Thank you all so very much. And my art face has been by Habils Couture. Habils Couture. They are at Adjiringano Gates, East Legon. You can call them at 0200 84 1988. 0200 84 1988. There are too many of you talking about my dress. Yeah, so get to them. Thank you. I'm Samson Ladia Yanini. God willing, next week we'll come your way with another edition of Newsfile. Have a good afternoon.